That crew, listen up. I know firsthand how limited a vessel medical insurance can be. This is why you need reliable medical coverage. Moore Dixon offers comprehensive global insurance tailored for yachties, covering everything from emergencies to routine checkups with flexible options and a single point of contact. Moore Dixon has been voted best health and medical insurance by captains and crew, including myself. Don't wait until the unexpected happens. Get covered today. Visit mdbl.im or email them at inquiries@mdbl.im for a free quote. Welcome to part 2 of our 3-part legal series, Death and Accidents at Sea. If you haven't listened to part 1, I highly recommend going back first. We cover what happens when a death occurs at sea from a legal perspective, and it lays the foundation for this conversation. Joining us again is Adria Notari, maritime lawyer who focuses her practice on accidents at sea. She is here to support the yachting community by helping us better understand our rights and the legal realities we may face. In this part, we're shifting the conversation to something many crew experience more often: accidents and injuries on board, and what you need to know legally when something goes wrong. So let's get into it. I like to shift the conversation to something many crew experience more often, which is serious accidents and injuries and what that means legally. If a crew member is seriously injured, whether on duty or off duty, what should they do right away to protect themselves legally?
Okay, so to protect, I would say even before you protect yourself legally, you want to protect yourself medically and get urgent medical care and treatment. Request urgent medical care and treatment. Report the situation. I have a serious incident. You want to make sure that you get the prompt medical care that you need. And guess what? It's the employer's obligation to provide it. So if you have a serious injury on board as a crew member, number one, report it. You know, I'm hurt and I need medical care now. That's the first thing to do. Now, once the medical condition is stabilized, then there are certain things that are very helpful from a legal standpoint. As I've said, the employer or their insurance company, they're going to undergo an investigation, and they're going to make sure that that investigation protects them as much as possible. And one of the things that they might do is they're going to ask the injured crew member for a statement. So on that statement, it's going to be skewed to protect the insurance company. So I would never, you as a crew member, you have to be very careful about saying like, what could I have done to prevent the incident, or whose fault was it? Anything like that. I would just steer clear of that. Those are legal conclusions, and you're a deckhand or a stew or a captain on a yacht. That's not your job to make legal conclusions about what caused the incident, what could have prevented it, whose fault was it? Was it no? So you should, as a crew member, don't be coerced into letting them put words in your mouth about assigning fault or blame for the incident. I would steer very clear of that. So after you get your medical care, don't make any conclusions about fault or responsibility. And then I would also document the incident as much as you can. If it's something that, you had an illness or injury in your workplace, take photos of the workplace. Give you an example. Oh, I tripped over a threshold on the yacht that was broken or something. Okay, take pictures of that. Document it from different angles so you can show, oh, that's what it looked like at the time of the incident before they have a chance to change it or fix it. Okay. Yeah. And then also make note of any possible witnesses. Even if someone didn't witness your injury or your incident, but if they have knowledge of the surrounding conditions, they have knowledge about the working conditions, they have knowledge that, that particular threshold that was broken before, and we told them about it and the company knew about it and they haven't done anything to fix it, if that fellow crew member or a possible, I mean, maybe even a passenger on a yacht charter, so any possible witnesses, you want to make note of that. I don't expect crew members to go be Sherlock Holmes and investigate these things, but just document these things, because in the future that's going to be very helpful for when you do consult with a lawyer. So medical care first. Don't make any conclusions on any incident reports or witness statements, and then take photographs if it's applicable. Take photographs of the incident scene, the area of the incident, your workplace, and then put a list of possible witnesses, because people's memories fade. So then 6 months later or 1 year later, you might forget, oh, what was the name of that person? I don't know. And if you at the moment of the incident, if you actually just keep log or lists somewhere of possible witnesses, that's going to be so helpful further on down the line.
And what about, this type of injuries that at the time they thought, oh, it's not a big deal. It hurts a little bit. I'm going to put some ice. It'll be fine. But then, a week, 2 weeks after, their back still hurting. And they didn't seek medical help at the time of the fall because they didn't think it was a big deal, or the people around them are like, oh, you're fine, just put ice. What is your advice around those type of injuries?
Well, we see that a lot. There are situations where at the moment, the person doesn't feel the full onset of pain. And maybe it's something that develops sometimes days later. That's not a problem. That's not a problem. That doesn't kill the case. On the contrary, there are a lot of medical journals that talk about situations like that, where at the time of the trauma, maybe with the person's adrenaline setting in, or that need to go back to work, you minimize the pain. We see that in like car accidents also, that a person at the moment of the car accident is in shock and they have adrenaline in their body and they don't even feel the pain on their neck or their whiplash. And then a couple of days later, it's like, wow, they're immobilized by this pain. So that shouldn't be a deterrent to having the proper medical care. The employer has to provide medical care and treatment, whether it was the yacht's fault or the crew member's fault, doesn't matter. The employer has to provide medical care and treatment. So if it's a situation that you don't feel the pain for a couple of days, that's fine. That can be part of the report. So you, as a crew member, tell your supervisor, I fell like 3 days ago and I didn't think anything of it, but now, oh, my back is killing me. I can't sleep. I can't touch my toes, whatever the situation, but explain it like that. That should be part of the report. And when I say part of the report, it doesn't have to be a formal report. It could just be telling your supervisor, that's reporting it. You told your supervisor that a couple of days ago, you fell down a ladder, and then now the pain is just debilitating and you need medical care. They still have an obligation to provide it.
If you go to get medical care, right? Because let's say you report it and they're like, okay, well, let's take you to the doctor. And then all of a sudden the doctor is like, oh my God, you need surgery. Are they responsible for financially supporting the surgery that you require? And are you meant to get the surgery on the country where the vessel is at the moment, or you're meant to get it where you're legally a citizen or resident that you can actually stay and recover during that time?
Okay, so there are legal questions and answers there, and also medical questions and answers. So legally, the employer has to provide the medical care that the crew member needs until the crew member reaches maximum medical improvement, or sometimes you'll see it called maximum medical recovery. That means that the injury that manifested during the contract, if it reaches a level where there's no possible improvement, they've just reached their maximum level of cure. Even if we provide surgery and treatment, they're not going to get any better than that level. So in the situation that you've described, If a doctor recommends surgery, then that's a medical question and you have to follow the doctor's orders. So yes, the employer is responsible for covering all of the medical expenses until the crew member reaches that plateau of maximum improvement, maximum cure, maximum recovery. I'll tell you though, the question about whether the crew member needs surgery or not, that's a medical question, right? So if a qualified doctor says that this person needs life-saving surgery, it's not up to the lawyer on the other side to say, oh no, I don't think the crew member needs surgery, because that's not a legal issue, that's a medical issue, whether the person needs surgery or not. If a medical evaluation based on medical diagnoses and the medical recommendation is to have surgery, then yes, the employer is responsible for all that. Why? Because it happened while the crew member was in the service of the vessel. The crew member is contributing to maritime commerce. Maritime commerce, this thing that maritime law wants to protect maritime commerce. Well, if the seafarer gets injured while that seafarer is contributing to this mission of maritime commerce, then the employer is responsible for providing the medical care that they need.
I have two questions. The medical care, are they supposed to supply it where the vessel is at the time, physically located, or to take the crew member, let's say they're South African, take you back to South Africa, repatriate you, and then you get your medical care in your country because obviously you're legally able to stay there and recuperate there?
That becomes a question of, medical emergency. How urgent is the situation? Is the crew member fit to fly? Sometimes the injury is so serious that the doctor won't even allow that crew member to fly on a plane back to South Africa, for the example that you mentioned. It's just they're not able to sit on a plane for that long because the doctor says, no, I'm not going to give you clearance for that because something could happen on the flight on your way home. So then that becomes like that's why I told you there's that intersection of the legal analysis, but also the medical,
Right.
the medical questions and the medical urgency. So we're going to follow the medical recommendations. In practicality, if it's not an urgent thing, then usually the crew member will be sent back to his or her home country and receive medical care and treatment there, because that's where their home and their family and their friends and their loved ones are. So it's also more convenient for the medical care.
I see a lot in the contracts, like you have up to 16 weeks or something like that, where like if you have an injury, basically they'll cover your salary for that amount. What's the entitlement for that period while you're still recovering and potentially coming back to the vessel, right? Because that's the idea. Like you go, you recover, and you come back. Do you still get paid your salary during that time of recovery? Plus, obviously, they're meant to take all the medical expenses on their side. How does that work? Is that only what's stipulated in the contract, or is there a different type of law that should be followed?
It depends on what flag the vessel is and what law governs the situation. If it's under United States maritime law, then the crew member is entitled to the medical care and treatment until they reach MMI, maximum medical improvement. And they're also entitled to the salary that they would have earned until the end of their contract. So, they were disembarked early because of the injury or because of the incident. The company, the employer, has to provide their contract wages until their end of contract date, then the medical care and treatment that they need until they reach that level of MMI, maximum medical improvement, and maintenance. It's called maintenance is like a daily stipend for like the equivalent of your room and board. That's under US maritime law. Under the MLC, that's limited to 16 weeks, like you've said.
What if your accident happens when you're off duty, right? Or your time off, or even maybe doing shore leave, right? Like when you're taking your rotation or you're on vacation, how does that legal picture change? And when does maritime law still apply if it doesn't happen on the vessel?
The employer's obligation to the crew member depends, most importantly, on whether the injury or illness happened during the seafarer's contract, their employment contract, or not during the seafarer's employment contract. So if it happens during the seafarer's employment contract, then it's almost always a situation where the employer has to provide the medical care that the crew member needs. Even if it happened when they're off duty, even if it happens like they were in the mess room having dinner at that moment and an illness or an injury occurred, they're not actively working, they're on their coffee break or on their meal break, it doesn't matter. If it's during the employment term, then the employer absolutely has to provide the medical care and treatment that the crew member needs. And I'll take it one step further. Suppose it happens when the crew member is ashore. Oh, crew member is ashore and they're just far away from the vessel, not even near the port anymore, not even near the marina anymore. And they're just doing something independent from the vessel. It doesn't matter. The crew member is still entitled to medical treatment because it happened during their employment contract. Yeah. And even if it's not the yacht's fault, right? If something happened ashore, it has nothing to do with the yacht. It's not something that the employer did something negligent or they should have provided some PPE or some safety precautions. Even if it has nothing to do with the negligence of the yacht, it doesn't matter. If the injury or the illness occurred during the contract of employment, the crew member is entitled to medical care and treatment. If it happened on vacation, then that gets trickier because the medical analysis becomes, well, when did the original symptoms of this illness or injury, when did the original symptoms manifest? If it happens like, oh, there was the start of an illness or injury during the contract, and then the contract ended, crew member went home on vacation, and then it got worse while they were on vacation, then maybe you can make a link and link it back to the vessel again, and then the employer of the vessel will have to provide the medical care and treatment. But if it's something that started, that arose and manifested, that's the word that they use a lot in the legal opinions. If the symptoms of the illness or the injury, if they manifested while the crew member is on vacation, then you can't really link it back to the employer. There's really no connection to the yacht in a situation like that. Then the crew member would be on their own.
When you mean contract, that does not include the time that is given to you on vacation through your contract.
Typically, no, that's not included in your contract, but an argument could be made. For example, if I have a sign-on date, let's say I have a sign-on date for a vessel like tomorrow. So today I go to the airport, from the airport, I travel overseas. And during that travel overseas, if an injury or illness happens, then maybe, yes, you can say that that was during the contract because the whole reason why I was traveling to the airport was to go catch the ship in the Mediterranean, for example. So in a situation like that, then you can say that it was during the service of my employment or during my employment contract, because I left my home. I was on my way to catch the yacht in the Mediterranean.
Right.
And during that time that I left my home, on my way, I hadn't arrived on the boat yet, but that was the whole purpose of me flying. And then if I hadn't had to do that, I wouldn't have gotten this injury or illness. And in a situation like that, yes, an argument can still be made that the employer has to be responsible for the crew member's medical care and treatment.
Looking back at real cases that you have had, what are the most common mistakes crew make after an accident or injury that later come back to hurt them?
After an incident, I've seen situations where the employer or the yacht management company or the yacht insurance company they'll undertake their investigation into the incident or injury. And one of the things that they'll require is that the crew member fill out an incident statement or an injury statement. And in that injury statement, crew members make determinations about what caused the incident or whose fault it was. That is the biggest mistake that a crew member can make. Like, first of all, at the moment of the incident or the injury, the crew member's mind is just not thinking clearly. So it's terrible to put yourself in that situation that you're letting these investigators basically take advantage of you and manipulate your high level of shock or pain or trauma about what just happened and try to make you make a determination about whose fault it was or who caused the injury or the incident. So crew members should never do that. Like, I don't know. That's the answer. I don't know what caused the incident. I don't or just leave it blank. Refuse to answer that. That's not your job, because that will be used against the crew members later on. It'll come back to haunt them. Later on, we'll do an investigation and we'll say like, oh, wow, this has been a documented failure for months and months and months. So this is not something that the company didn't know about. They knew about it and they just didn't fix it for such a long time. But the crew member creates an unnecessary conflict, another unnecessary hurdle in their case by talking about whose fault it was and what caused the injury. So I would just steer clear of that. You're not a forensic expert. You're not a detective. You don't have to make determinations about what caused the injury or the incident. And then number two, another thing I would say is not taking advantage of the fact that you are there on board and document the instrumentalities involved, the equipment in your workplace, whatever contributed to the incident, because it's very hard afterwards, months later, to recreate that with just words. A picture is worth 1,000 words. So if you have pictures of what was actually involved in the incident, that's so helpful when you show that to your lawyer, or if we have experts involved. It's so helpful. It's invaluable. And unless you still have another close friend or colleague on board that can take those pictures for you, a trusted person that can take pictures for you, you miss that opportunity. And then you just got that regret. One more thing that comes to mind is the severity of the injury. If there's just as an example, if you're a crew member and you got burned on board, if the burn is serious, you receive the medical attention, you've been bandaged, 6 months later, you've still got scarring or whatnot. But if you didn't preserve a picture of what the injury looked like at the beginning, before you got all that medical care, you don't have a chance to recreate that in the future. You can testify about it, but again, that valuable picture is worth 1,000 words.
And let's talk about responsibility. How does alcohol, fatigue, long hours, understaffing, or lack of rest factor into legal responsibility when accident happens?
Alcohol. If there's alcohol involved, alcohol impairs people's judgment. So if the vessel doesn't have an alcohol policy that they enforce or they use to prevent incidents or control when crew members can or cannot consume alcohol, then that's something that we're going to uncover in our investigation. And more likely than not, you're going to be able to attribute that. Did alcohol play a role in the injury or incident? And it usually does. Alcohol impairs people's judgment. It's just a scientific fact. So if you know that, just in general, there are a lot of maritime hazards on vessels. There are just more opportunities to get injured or have an incident in the workplace on vessels. So a responsible management company or a responsible employer should have some sort of alcohol policy on board. And if a crew member is injured or assaulted, we see alcohol playing a huge role in cases of sexual assault on vessels. So if the employer doesn't have an alcohol policy or any kind of rules and everything is just a free for all, and then crew members are over consuming alcohol, abusing alcohol, and then abusing other crew members, well, that's something that contributes to the unseaworthiness of the vessel. So we can say, like, that makes the vessel unfit. That makes the vessel unsafe. And some people have violent propensities when they consume alcohol. So yes, alcohol is a huge factor in these cases. The other ones are fatigue, understaffed, and lack of adequate rest hours. Those are also huge factors. Under U.S. maritime law, the bulk of our cases come under something called the Jones Act, which is the employer did something that was negligent. They allowed something or a situation that was negligent or negligence. They allowed the negligence to happen on board. Okay. But then another theory of liability is called seaworthiness or unseaworthiness. As a crew member, you're entitled to have a seaworthy vessel. And what does that mean? It means the vessel has to be fit for the intended purpose of the vessel. The vessel has to be fit, structurally fit, of course. The equipment has to be fit, but what else? The crew has to be fit. So all of those things that you mentioned, fatigue, understaffed, and lack of adequate rest hours or adequate rest time, all of those things contribute to the unseaworthiness of the vessel. I mean, can you picture it? If the vessel doesn't have sufficient crew members for the intended task, then that vessel is not fit. It's not fit because of the crew. Either not enough crew members, or the crew is overworked, or the crew is fatigued to the point that they're almost drunk because they're just physically exhausted. So that's going to contribute to the unseaworthiness, and it takes away from the fitness of the vessel. So yeah, all of those things are factors that help us help us attribute fault to the owner or employer.
Mm. And what about the witnesses? For crew witness, a whether that be a fatal accident like a death or an injury, what are the legal protections that exist if they're afraid of speaking up or facing retaliation for actually telling the truth?
For crew members, there are, in the United States law, there are statutory protections against that kind of retaliation. So if a seafarer sees a dangerous situation on board, or they make a complaint about a physical or negligence or injury or some situation that happened to them, then by law, the seafarer has protections and the company cannot retaliate against them. And if they do retaliate against them or discriminate against them or demote them or terminate them or whatever the case may be, then there are legal remedies. And under international labor conventions, under the ILO as well, there are similar protections. So crew members shouldn't be I know they're still going to be afraid to speak out, but they shouldn't be, because there are protections in place that the employer cannot retaliate against you for speaking up about something, for even for reporting a dangerous situation to, let's say, to the Coast Guard or to Port State Control. And if the employer does do that, then yeah, you have a case for wrongful termination and for retaliatory discharge. Another thing that crew members shouldn't be afraid of doing is speaking out if the employer is asking them to do something that's dangerous. If there's no obligation in your life over a job or over a charter, and everyone is like working in a rushed pace because of the pressures of yacht life or just the exigencies of of work. There's no reason, there's no obligation for you to lose your life or be injured for something like that. So again, under these seafarer protections, you have a right to refuse to work. Now, you can't just say, oh, I'm not going to do that. Go pound sand. I'm out of here. That's unreasonable. It has to be like you have a reasonable apprehension that that task that you're being asked to do, that job, that assignment is just, it's unreasonably dangerous. That a reasonable crew member in your same situation would say, that's dangerous to do that. So like situations like working aloft without proper harness protection, you can refuse to do that. And the steps to take are, first you have to tell your supervisor or your employer, you have to report, you have to say like, I think that's dangerous to do it like that. I don't feel comfortable working like that. You have to give the employer or give the supervisor an opportunity to fix it first. And then you can refuse to work. You can say like, no, I'm not going to work under these unsafe conditions. Because many times then after the fact, then we see these incidents or, lessons learned, but why sacrifice your life or your health, your livelihood, your life and limb over a job? It's just simply not worth it. And that's another situation. The company or the employer, they can't fire you for doing that. You have a right to bring it to their attention and give them an opportunity to make it safe first.
If you could give one advice about accidents and injuries at sea for seafarers, what would be your top advice for everybody who's listening?
I would say to consult with an attorney. A lot of times crew members think, oh, there's nothing I can do. It wasn't the company's fault. Or maybe it's an illness that, well, the company didn't cause the illness. Maybe I don't have a claim. Crew members shouldn't be afraid to consult with attorneys and get legal advice to know like what their rights are when there's an injury or an incident. That would be like the number one thing. And also to consult an attorney before it's too late. So different countries have different statutes of limitations under maritime law for crew members. So I would say the number one advice would be to consult an attorney.
Because in the industry for so long, attorneys have been viewed as they only support the employer, not the employees. There's almost like this stigma for seafarers to even look for support of a lawyer. And there's also the financials, because a lot of people think, well, I don't have the money. It's going to cost me a lot. I'm not going to consult a lawyer. So they shoot themselves in the foot, right? Because they
shoot themselves in the foot. Yes, they do. Because a lawyer can advise you, and my initial consultation is free. I will listen to the crew member's story and I'll advise them. Yes, you have a case. No, you don't have a case. This can be done. That can be done. What are your options? Maybe you can't do anything, but maybe you can do something. And then after that, we'll discuss the process, what are the remedies, and what are the possible solutions. In my situation, I don't recover attorney's fees unless I recover money compensation for the crew member. So there's not going to be a situation where the crew member is paying me hourly bills and paying me for my time before the crew member has recovered any money, and then we lose the case, for example,
Right.
Forbid. But so in my situation, that's what I work on, a contingency fee basis. It's contingent on if I recover for the crew member, then I recover salaries as well. If I don't recover anything from the crew member doesn't owe anything. So that financial fear, oh, how am I going to pay for the attorney? That shouldn't even come to mind, especially if you're dealing with a maritime attorney in the United States. Other countries might not recognize this contingency fee arrangement, but we're very fortunate that here in the United States we do, because then the crew member they at least have a chance to get an evaluation and be advised. It's not just for the rich yacht owners and the rich companies, it's also for the individual crew member who's really hurt.
That brings us to the end of part 2, where we have focused on accidents, injuries, reporting, and the legal realities crew may face when something goes wrong. If you haven't listened to part 1, I encourage you to go back. It gives important context to everything we have discussed here. In part 3, we'll move into legal support, when to contact a lawyer, how to choose the right one, and what crew and families can do to better protect themselves before something happens. And while you're waiting for the next episode, if you haven't watched our Seafarer Rights series with Adria, I highly recommend checking it out. The links are below. See you in the next episode.
If your brand belongs in the heart of the yachting world, this is where it happens. Yachting International Radio reaches over 1 million yachting professionals and enthusiasts every month, with 77 million impressions, 220,000 social followers, and 74,000 podcast subscribers. Our hosts are insiders, crew, captains, CEOs, trusted voices shaping the industry. This is targeted, high-impact advertising in a luxury niche. Visit yachtinginternationalradio.com/advertise. Your audience is already listening.